Public Protector Busisiwe Mkhwebane has filed a second application with the Constitutional Court to rescind its judgment, this time around her impeachment. The papers were filed on Friday, and according to her affidavit, the Constitutional Court judgment contains patent errors. Now, the judgment found that the rules for the impeachment of Chapter 9 institutions were unconstitutional. In short, it does pave the way for her potentially to be impeached. We're now joined by legal expert advocate Modidima Mannya. Advocate, I hope you can hear me this time. I was talking about rescission applications. We didn't know much about them until the former president applied for one. And now we have the public protector applying for two rescission applications. Just remind us what the court is being asked to do and tell us what you think her chances of success in the second case are.
Yes, good evening, Francis and your viewers. Look, as a matter of law, all the courts can reconsider and rescind their judgments or orders subject to certain requirements being met, one of which is when a judgment is given in the absence of a party, or there is an error, or there is some ambiguity in the order. Now, in the particular situation, the matter, just by way of background, started in the Western Cape High Court, where the public protector challenged the rules passed by the National Assembly, which basically in simple terms relate to holding Chapter 9 institution office bearers accountable. She had about 12 grounds. The court dismissed 10 of the grounds and sustained 2. In respect of the 2, one related to her right to full legal representation. And the court found that the rules, to the extent that they exclude her right to legal representation, were unconstitutional. Then there was a question of the judge who served on the independent advisory panel. The court found that it was undesirable to have a judge because that offends on the separation of powers. She then approached the Constitutional Court on appeal. The court confirmed the order insofar as it relates to legal representation. But then it said the test applied by the High Court in the Western Cape of undesirability was wrong. The question was whether it was permissible. And the court felt that there was nothing wrong if a judge is appointed, because that judge is in any event appointed in consultation with the Chief Justice. Now, she has gone back to the same court to say, look, you made a patent error, and I understand, amongst others, her to be saying, you didn't say under which law, whether statute or whatever, the National Assembly can make these rules. But the answer to that lies in Section 57 of the Constitution, which gives the Parliament, or the National Assembly in particular, the authority to make rules to regulate its business. So the process of holding Chapter 9 institutions accountable falls within the power of the National Assembly, and the National Assembly is in any event authorized to make rules to deal with that aspect.
All right, so assess for us her chances of success here?
Well, look, from what it seems, I'm not sure what the real complaint is. The fact that the court didn't specify the section of the Constitution doesn't mean that section of the Constitution doesn't exist, and it doesn't mean the National Assembly doesn't have authority. I think the challenge is not really to the power of the National Assembly to make rules. If that is the case, then Section 57 covers the National Assembly. So in real terms, I'm not sure whether there's any real cogent basis for an application for rescission.
Yeah. And once the application, if it is turned down, that will be the end of the road. So do you agree then that it paves the way or smooths the way for her potentially to be impeached by Parliament? And in this case now, a judge can be appointed by Parliament. Is that the situation?
Well, the judge's role related to the investigative part to determine whether there was a prima facie basis to subject her to a tribunal to determine her fitness for office. So no judge is going to participate in the actual inquiry. It's going to be conducted by members of Parliament. In fact, as matters stand, Parliament, as I understand, is on course to proceed. There's nothing that bars it from proceeding with the process. I think we should not assume that the final product will be her impeachment. I think at the moment the process is about determining whether her conduct is impeachable or not, and if the inquiry finds that it's impeachable, that resolution will be tabled in the National Assembly, and that is where a decision to impeach will be taken. So the committee that is doing the work is not going to determine whether she should be impeached. It will make a recommendation to the National Assembly.
Yeah. We saw in the case of the former president, the Constitutional Court did take umbrage at some language. Do you think the court will be concerned at all about her saying she could be suspended by a biased president if this judgment is upheld? And then she talks about the court's ruling, and she said that it has failed to apply the most basic rules for constitutional validity and the rule of law, as well as the established in the well-known pharmaceutical and FedSure cases. I don't know if you can enlighten us about those cases, but saying that the Constitutional Court is failing to apply the most basic rules.
Well, the judgment of the court in this matter, the court relied on its own jurisprudence in the Personal Injuries Association matter, not the ones that she's referring to per se. But I think the language as well, it's a bit untenable. I'm not sure how one addresses the court in that manner. But I think the bottom line in this matter is that I don't think the public protector wants to be held accountable, because I think every other issue that could have been a bar to a fair hearing has been addressed. And she is responsible for holding others accountable or ensuring that they are held accountable. And I think it's just fair for her to subject her to this process and let a determination be made. Yeah. She would still have the right to take the matter to court if she feels that the process was not correctly followed or the decisions were not rational.
Before you go, let's quickly look at the previous judgment of the Constitutional Court, which she failed to have rescinded. The court in that case found she altered the words of the Executive Ethics Code to justify a finding that President Cyril Ramaphosa ethically misled Parliament. So would that add to the ammunition of her critics who believe that she needs to be impeached? And are you surprised? I mean, surely altering words of something that is easily accessible. Are you surprised of what she did in this case?
Well, look, I think it may as well be that she may have used words that are not in the act, but it may not necessarily mean she was malicious. I think the process of the National Assembly has to determine whether this was probably a matter of ineptitude or misinterpretation, or there was an intention indeed to find a basis to find the president guilty of wrongdoing by any means. But I think it would be dangerous to make such a call at this stage. I think it is the process of the National Assembly which must make that determination. She must give evidence before the committee. She must be asked questions. She must make representations, and based on that, a proper determination can be made.
All right. Thank you so much for your time tonight. That was legal expert advocate Modidima Mannya.